With regard to the present situation, Israel must, in accordance with its obligations under the Genocide Convention, in relation to Palestinians in Gaza, take all measures within its power to prevent the commission of all acts within the scope of Article 2 of the Convention, in particular.
On January 26, 2024, the International Court of Justice (ICJ) issued provisional measures in the case brought by South Africa accusing Israel of violating the Genocide Convention. This legal action stemmed from South Africa's filing of proceedings against Israel on December 29, 2023, alleging breaches of the Convention on the Prevention and Punishment of the Crime of Genocide in relation to the Palestinian population in the Gaza Strip. In its application, South Africa sought provisional measures from the court to prevent further harm to the rights of the Palestinian people under the Genocide Convention and ensure Israel's compliance with its obligation to prevent and punish genocide. The ICJ, in response, mandated urgent measures for Israel to prevent acts falling under the scope of the Genocide Convention during its military actions in Gaza. The majority of the 17-judge panel supported these measures, excluding a ceasefire order.
Killing members of the group. B. Causing serious bodily or mental harm to members of the group. C. Deliberately inflicting on the group conditions of life calculated to bring about its physical destruction in whole or in part. And D. Imposing measures intended to prevent births within the group. The Court recalls that these acts fall within the scope of Article 2 of the Convention when they are committed with the intent to destroy in whole or in part the group as such. The Court is also of the view that Israel must take measures within its power to prevent and punish the direct and public incitement to commit genocide in relation to the members of the Palestinian group in the Gaza Strip.
Human Rights Watch's Balkis Jarrah noted that the ICJ's decision serves as a crucial warning to Israel and its allies to take immediate action to prevent genocide and atrocities against Palestinians in Gaza. The court emphasized the need to protect the plausible rights claimed by South Africa, specifically highlighting the rights of Palestinians in Gaza to be shielded from acts of genocide. The ICJ's order also compels Israel to prevent the destruction of evidence related to the case, ensure evidence preservation, and submit a report on the implementation of the measures within 1 month. Despite compelling evidence, Benjamin Netanyahu continued to deny the charges.
The charge of genocide leveled against Israel is not only false, it's outrageous, and decent people everywhere should reject it.
This landmark ICJ ruling is legally binding on all parties involved. South Africa's Minister of International Relations and Cooperations, Naledi Pandor, hailed the judgment as a victory for the people of Palestine.
Thanking the judges of the International Court of Justice for dealing with this matter expeditiously, given the urgency of the need to protect innocent civilians in Palestine and to ensure that the harm that South Africa has referred to in the case it brought before the ICJ, that harm is addressed and that people's lives are saved. The saving of life is not merely with respect to having a ceasefire, it's to ensuring that humanitarian aid is provided to those who need support, as well as ensuring that the State of Israel, which is currently the occupier and administrator in Palestine, provides the necessary basic services that the residents of Gaza and the West Bank require.
Notably, this case differs from criminal proceedings against individual perpetrators as it constitutes state-to-state litigation among UN member states, governed by legal provisions in the UN Charter, the ICJ Statute, and the Genocide Convention.